You're listening to Women's Media Center Live with Robin Morgan.
Welcome to Women's Media Center Live. I'm Robin Morgan. Today we are going to rummage around in the legal system, sometimes humorously known as the justice system. We're going to take a look at the history of the Supreme Court, its great justices and its horrific ones, its landmark decisions and its low watermark devastating ones, and just why and how expanding the number of justices' seats on the court is not an impossible notion. And since we'll be in the justice system, in fighting words, we're going to look at the verdict. Yes, the verdict in the murder of George Floyd and the conviction of Derek Chauvin. It's been coming, you know, since 1619. Quite a wait. So let's see first what's inside the headlines. The Supreme Court of the United States, sometimes shorthanded as SCOTUS, S-C-O-T-U-S, is the highest court in the federal judiciary of the United States of America. It has ultimate and largely discretionary appellate jurisdiction over all federal and state court cases that involve a point of federal law, and it has original jurisdiction over a narrow range of cases, specifically, quote, all cases affecting ambassadors, other public ministers and consuls, and those in which a state shall be a party, close quote. The court holds the power of judicial review, which is the ability to invalidate a statute for violating a provision of the Constitution. It's also able to strike down presidential directives for violating either the Constitution or statutory law. However, it may act only within the context of a case in an area of law over which it has jurisdiction. The court may decide cases having political overtones, but it has ruled that it does not have power to decide non-justiciable political questions. Established by Article 3 of the Constitution, the composition and procedures were initially established by the first Congress through the Judiciary Act of 1789. As later set by the Judiciary Act of 1869, the court consists of the Chief Justice and 8 associate justices. Each has a lifetime tenure, meaning they remain on the court until they resign, retire, die, or are removed from office. When a vacancy occurs, the President, with the supposed advice and consent of the Senate, appoints a new justice. Each justice has a single vote in deciding the cases argued before it. When in majority, the chief decides who writes the opinion of the court. Otherwise, the most senior justice in the majority assigns the task of writing the opinion. Those are some of the basics. It was while debating the separation of powers between the legislative and executive departments that delegates to the 1787 Constitutional Convention established the parameters for the national judiciary. Creating a so-called third branch of government was itself a novel idea. See, in the English tradition, judicial matters had been treated as an aspect of royal executive authority. Early on, the delegates who were opposed to having a strong central government argued that national laws could be enforced by state courts, while others, including James Madison, advocated for a national judicial authority consisting of various tribunals chosen by the national legislature. It was also proposed that the judiciary have a role in checking the executive's power to veto or revise laws. In the end, the framers compromised by sketching only a general outline of the judiciary, vesting federal judicial power in, quote, one Supreme Court and in such inferior courts as the Congress may from time to time ordain and establish, close quote. They delineated neither the exact powers and prerogatives of the Supreme Court nor the organization of the judicial branch as a whole. This kind of, depending on how you view it, either sloppiness or open-handedness to permit growth, was common during those early convenings of the framers. The first United States Congress provided the detailed organization of a federal judiciary through the Judiciary Act of 1789. The Supreme Court, the country's highest judicial tribunal, was to sit in the nation's capital and would initially be composed of a Chief Justice and 5 associates. The act also divided the country into judicial districts, which in turn were organized into circuits. Justices were required to ride circuit and hold circuit court twice a year in their assigned judicial district, of which there were 13. Keep that number in mind. The court got off to a slow start with cases that were almost non-existent or some that involved procedural matters. But the court's power and prestige grew substantially during the Marshall Court. Chief Justice Marshall, under him, the court had the power of judicial review over acts of Congress. That included specifying itself as the supreme expositor of the Constitution in Marbury versus Madison. And it also had the authority to make several important constitutional rulings that gave shape and substance to the balance of power between the federal government and states. The Marshall Court also ended the practice of each justice issuing an opinion seriatim, a remnant of British tradition, and instead issuing a single majority opinion. And during Marshall's tenure, though beyond the court's control, the impeachment and acquittal of Justice Samuel Chase in 1804-05 helped cement the principle of judicial independence. Now, the Taney Court, we're now looking at the period from Chief Justice Taney to Taft. The Taney Court, that's 1836 to 1864, is primarily remembered for its disastrous, ghastly ruling in Dred Scott versus Sanford, which helped precipitate the Civil War. The Dred Scott decision was a landmark decision in which the court held that the U.S. Constitution was not meant to include American citizenship for black people, regardless of whether they were enslaved or free, and so the rights and privileges that the Constitution confers upon American citizens could not apply to them. Although Chief Justice Taney and several other justices hoped that the decision would permanently settle the slavery controversy, which was increasingly at the time dividing the American public, the decision went in exactly the opposite direction. It suited the slaveholding states, but it was intensely decried in all the others. It inflamed the national debate over slavery and deepened the divide that led ultimately to the Civil War. In 1865, after the Union won the Civil War, the ruling was voided entirely by the 13th Amendment to the U.S. Constitution, which abolished slavery except as punishment for a crime, and the 14th Amendment, which guaranteed citizenship for all persons born or naturalized in the United States and subject to the jurisdiction thereof. In the Reconstruction era, the Chase, Waite, and Fuller courts interpreted the new Civil War amendments to the Constitution and developed the doctrine of substantive due process. Under the White and Taft courts, the court held that the 14th Amendment had incorporated some guarantees of the Bill of Rights against the states, and it grappled with the new antitrust statutes and upheld the constitutionality of military conscription. During the New Deal era, this was the courts under Chief Justices Hughes, Stone, and Vincent, the court gained its own accommodation and changed its interpretation of the Constitution, giving a much broader reading to the powers of the federal government in order to facilitate President Franklin Roosevelt's New Deal. During World War II, the court continued to favor government power, upholding, on the other hand, the internment of Japanese citizens in Korematsu and the mandatory Pledge of Allegiance. The Warren and Burger Courts, 1953 and thereafter, dramatically expanded the force of constitutional civil liberties. It held that, this is the Warren Court, that segregation in public schools violates the Equal Protection Clause of the 14th Amendment, that legislative districts must be roughly equal in population. It created a general right to privacy in Griswold versus Connecticut. It limited the role of religion in public schools. It incorporated most guarantees of the Bill of Rights against the states, and it required that criminal suspects be apprised of all those rights by police. But the Burger Court marked a conservative shift. It also expanded the right to privacy to strike down abortion laws in Roe v. Wade. That's a landmark. But it was divided deeply on affirmative action and on campaign finance regulation, and it wavered on the death penalty. And later on, the death penalty itself was ruled not unconstitutional. Rehnquist and Roberts, well, those courts moved even further to the right. The Rehnquist Court was noted for its revival of judicial enforcement of federalism, emphasizing the limits of the Constitution's affirmative grants of power. And the court's decision in Bush v. Gore ended the electoral recount during the presidential election of 2000 and became particularly controversial. The Roberts Court, 2005 to the present, is more conservative than the Rehnquist Court. Some of its major rulings have concerned federal preemption, civil procedure, abortion, climate change, same-sex marriage, actually that was a good one, and the Bill of Rights, most notably and tragically in Citizens United versus Federal Election Commission. So that's a brief eagle's eye view of the court's decisions. Now, in terms of tenure, the Constitution provides that justices shall hold their offices during good behavior. The term is understood to mean that justices may serve for the remainder of their lives unless they're impeached and convicted by Congress or resign or retire. Only one justice has been impeached by the House of Representatives. That was Chase in 1804, but was acquitted in the Senate. Despite the variability, all but 4 presidents have been able to appoint at least one justice. William Henry Harrison died a month after taking office, though his successor, John Tyler, made an appointment during that presidential term. Likewise, Zachary Taylor died 16 months after taking office, but his successor, Millard Fillmore, also made a Supreme Court nomination before the end of that term. Andrew Johnson, who became president after the assassination of Lincoln, was denied the opportunity to appoint a justice by a reduction in the size of the court. Jimmy Carter is the only person elected president to have left office after at least one full term without having the opportunity to appoint a justice. Presidents James Monroe, Franklin Roosevelt, and George W. Bush, each served a full term without an opportunity to appoint a justice, but they made appointments during their subsequent terms. No president who has served more than one full term has gone without at least one opportunity to make an appointment. And as for the size of the court, well, there's a great deal of folderol now about whether we should expand the court because its tilt to the right is so extreme, or whether that's constitutional, or whether it's not. And my goodness, has it ever been done? Can it be done? Should it be done? Well, Article 3 of the Constitution sets neither the size of the Supreme Court nor any specific positions on it, although the existence of the office of the Chief Justice is tacitly acknowledged in Article 1, Section 3, Clause 6. Instead, these powers have typically been entrusted to Congress, which initially established a 6-member Supreme Court composed of a Chief Justice and 5 associates. That was through the Judiciary Act, you remember, of 1789. The size of the court was first altered by an 1801 act, which would have reduced the size to 5 members upon its next vacancy. But then an 1802 act promptly negated the 1801 act, legally restoring the court's size to 6 members before any such vacancy occurred. As the nation's boundaries grew across the continent, and as Supreme Court justices in those days had to literally ride the circuit, an arduous process requiring travel on horseback or carriage over harsh terrain, resulting in months-long extended stays away from home, well, Congress added justices to correspond with the growth. 7 more in 1807, up to 9 in 1837, and 10 in 1863. In 1866, at the behest of Chief Justice Chase, and in an attempt to limit the power of Andrew Johnson, Congress passed an act providing that the next 3 justices to retire would not be replaced, which would thin the bench to 7 justices by attrition. Consequently, 1 seat was removed in 1866, a second in 1867. In 1869, however, the Circuit Judges Act returned the number of justices to 9, where it has since remained. President Franklin D. Roosevelt attempted to expand the court in 1937 with a complex proposal envisioning the appointment of 1 additional justice for each incumbent justice who reached the age of 70 years, 6 months, and refused retirement. But the purpose behind his plan was pretty much understood as an effort to, quote, pack the court with justices who would support the New Deal. One of the suggestions is to expand the number to 13, the original number of circuits, which is kind of a nice number, also happens to be the same number of a witches' coven. And last but not least, the court has currently 6 male and 3 female justices. Among the 9, there is 1 African American, Justice Thomas, and 1 Hispanic, Justice Sotomayor. 1 of the justices was born to at least 1 immigrant parent. Justice Alito's father was born in Italy. At least 6 are Roman Catholics, 2 are Jewish. It's unclear whether Neil Gorsuch considers himself Catholic or Episcopalian. Historically, most justices have been Protestants, including 36 Episcopalians, 19 Presbyterians, 10 Unitarians, 5 Methodists, and 3 Baptists, all those Christians. The first Catholic justice was Roger Taney in 1836, and the first Jewish justice was appointed Louis Brandeis in 1916. For much of the court's history, every justice was a man of Northwestern European descent. Racial, ethnic, and gender diversity in the court increased in the late 20th century, with Thurgood Marshall becoming the first African-American justice in 1967. Sandra Day O'Connor became the first female justice in 1981. There have been 6 foreign-born justices in the court's history. Did you know that justices could be foreign-born? They can. As for their salaries, as of 2018, associate justices received a yearly salary of $255,300, and the chief justice is paid $267,000 a year. Those are the Supremes. We have to take a brief pause here, but we'll be back directly with the Surrealism Corner. Oh, Supreme Court? Surrealism, you think? Subscribe to this program on your favorite podcast platform and leave us a review. Follow us on Twitter at WMC Live, like our Facebook page at facebook.com/WMC Live, and visit us at WMCLive.com for more information about our show and our guests.
You're listening to Women's Media Center Live with Robin Morgan.
a conflation of ideas, an intersectionality of thinking. That too can comprise the Surrealism Corner. A number of you wrote in about the lemon test, which I mentioned in a previous recent broadcast about keeping church and state separate. And the so-called lemon test, are three tests that have evolved from various Supreme Court decisions over time to decide the constitutionality of laws with a religious component. Well, these are the three: the lemon test, the endorsement test, and the coercion test. Now, the first, the lemon test, Lemon versus Kurtzman, 1971, is that a statute or public policy must have a secular legislative purpose. 2, the principal effect of the statute or policy must neither advance nor inhibit religion. And 3, the statute or policy must not foster excessive government entanglement with religion. Now, 2, the endorsement test, that's Lynch versus Donnelly, 1984. Well, Justice Sandra Day O'Connor first framed this doctrine that if a law favors one religion over another in a manner that makes some people feel like outsiders and others feel like insiders, that law is unconstitutional. Later, after lower courts took her ruling to mean that the phrase "under God" in the Pledge of Allegiance unconstitutionally endorses monotheism, she backpedaled, although they were quite right. In a decision voiding the lower court finding, O'Connor then framed this new 4-part subtest to govern so-called ceremonial deism. Honestly, doesn't this belong in the Surrealism Corner? Ceremonial deism. Such acts as the pledge are constitutional. They are, if they, 1, are historical and ubiquitous, 2, are not worshipful or prayerful, 3, don't refer to a particular religion, and 4, involve minimal religious content. That's pretty funny, the endorsement test. And 3 of these 3 tests is the coercion test. That was Lee v. Weisman, 1992, first enunciated by Justice Anthony Kennedy in a graduation ceremony prayer case. This so-called psychological coercion standard holds that a law is constitutional even if it recognizes or accommodates a religion, so long as its demonstration of support does not appear to coerce individuals to support or participate in a religion or religious exercises. Now, I could argue all 3 of those, that if there's peer pressure on a kid to pray in a school auditorium, that's coercion. I could certainly argue against O'Connor in her intricate, contorting backpedaling about the endorsement test. The lemon test itself basically sounds sensible, though. A statute or public policy must have a secular legislative purpose. The effect of the statute must be neither to advance nor inhibit religion, and the statute must not foster excessive government entanglement with religion. Seems pretty sensible to me. Not at all surreal. We have to take a quick final break here, but I'll be back directly with some fighting words. The Women's Media Center, founded in 2005 by Jane Fonda, Gloria Steinem, and myself, is a progressive, nonpartisan, nonprofit organization working to make women visible and powerful in media. You can learn more about the WMC at womensmediacenter.com.
You're listening to Women's Media Center Live with Robin Morgan.
Fighting words are often about language itself. Expectable cliches are mouthed in this country every time another atrocity is committed. Thoughts and prayers, sympathies and condolences, processing, trauma, healing, closure. Plastic words describing styrofoam sentiments. They have no meaning, no content. They litter our oceans, congest our conversations, pollute our oxygen. Not even sound and fury, but still signifying nothing. We groan these platitudes when there's another school shooting or supermarket massacre, when another black citizen gets killed by another white cop, when another woman's body is found somewhere in some other bathroom or kitchen. Thoughts and prayers are with you. They say the verdict last week was different. It was. And it wasn't. It was because it validated to a microscopic degree the screaming injustices in our court systems. It was because it comforted a family, though their family member was forever lost. It was because it ever so slightly began to erode the blue wall of police silence and collaboration. It was because it reinforced the actions of Kelly Mae Jong, Chauvin's former wife, a Khmer Laotian woman who divorced him in May 2020 after the murder. White Americans, impatient people, are eager for this to be over, for things to go back to being normal, for people to stop complaining, for Christ's sake. Even the young idealistic ones, the ones marching peaceably, yet with fists in the air, they too are impatient. They stand ready to win, ready to be elated. But look closer at the older faces. Look in the eyes. Listen to the darker-skinned ones. Listen to those who say calmly that perhaps the verdict was a beginning. Certainly it seemed positive. Maybe it could mean change. The way it was supposed to mean change after the Civil War, the way change was certain with Reconstruction, the way it was meant to mean change when Jim Crow settled in, change before the black codes made change itself a word of bitter cynicism. Another small window, another fragile hope, summed up perhaps by two words: we'll see. Time alone will tell if it's different. Time alone will tell if it will be translated into action, legislation, enforced practice, and possibly, eventually, almost unimaginably, into regular procedure. Racism runs so deep, deeper than an underground river, like the river Styx in this country. It saturates the soil. It saturates the soul. Such moments send me back for inspiration, discipline, wisdom, to Toni Morrison's voice. In this case, in particular, from her book Playing in the Dark, Whiteness and the Literary Imagination, which consists of 3 essays that formed the basis of a course in American literature she taught at Harvard. Here are a few of these bracing, challenging, brilliant thoughts. Young America distinguished itself by, and understood itself to be, pressing toward a future of freedom, a kind of human dignity believed unprecedented in the world. A whole tradition of universal yearnings collapsed into that well-fondled phrase, the American dream. Although this immigrant dream deserves the exhaustive scrutiny it's received in the scholarly disciplines and the arts, it is just as important to know what these people were rushing from as it is to know what they were hastening to. If the New World fed dreams, what was the Old World reality that whetted the appetite for them? And how did that reality caress and grip the shaping of a new one? The flight from the old world to the new is generally seen to be a flight from oppression and limitation to freedom and possibility. Although, in fact, the escape was sometimes an escape from license, from a society perceived to be unacceptably permissive, ungodly, and undisciplined. For those fleeing for reasons other than religious ones, constraint and limitation impelled the journey. All the old world offered these immigrants was poverty, prison, social ostracism, and, not infrequently, death. There was, of course, a clerical, scholarly group of immigrants who came seeking the adventure possible in founding a colony for, rather than against, one or another mother country or fatherland, and of course there were the merchants who came for the cash. Whatever the reasons, the attraction was one of the clean slate variety, a once-in-a-lifetime opportunity not only to be born again, but in new clothes, as it were. The new setting would provide new raiments of self. The second chance could even benefit from the mistakes of the first. In the new world there was the vision of a limitless future, made more gleaming by the constraint, dissatisfaction, and turmoil left behind. It was a promise genuinely promising. The desire for freedom is preceded by oppression. A yearning for God's law is born of the detestation of human license and corruption. The glamour of riches is in thrall to poverty, hunger, and debt. There was very much more in the late 17th and 18th centuries to make the trip worth the risk. The habit of genuflection would be replaced by the thrill of command. Power, control of one's own destiny, would replace the powerlessness felt before the gates of class, caste, and cunning persecution. One could move from discipline and punishment to disciplining and punishing, from social ostracism to social rank. One could be released from a useless, binding, repulsive past into a kind of historylessness, a blank page waiting to be inscribed. Much was to be written there. Noble impulses were made into law and appropriated for our national tradition. Base ones, learned and elaborated in the rejected and rejecting homeland, were also made into law and appropriated for tradition. The body of literature produced by the young nation is one way it inscribed its transactions with these fears, forces, and hopes, and it is difficult to read the literature of young America without being struck by how antithetical it is to our modern rendition of the American dream. For a people who made much of their newness, it is striking how dour, how troubled, how frightened and haunted our early and founding literature truly is. We have words and labels for this haunting: Gothic, Romantic, Sermonic, Puritan, whose sources are to be found in the literature of the world these immigrants left. But the strong affinity between the 19th century American psyche and Gothic romance has rightly been much remarked. An answer to that seems fairly obvious. One way to benefit from the lessons of earlier mistakes and past misfortune is to record them so as to prevent their repetition through exposure and inoculation. Romance was the form in which this uniquely American prophylaxis could be played out. Long before the movement in Europe, romance remained the cherished expression of young Americans. What was there in American romanticism that made it so attractive to Americans as a battle plain on which to fight, engage, and imagine their demons? I am more persuaded by arguments that find it in the head-on encounter with very real, pressing historical forces and the contradictions inherent in them as they came to be experienced by writers. Romance, an exploration of anxiety imported from the shadows of European culture, made possible the sometimes safe and other times risky embrace of quite specific, understandably human fears. Americans' fears of being outcast, of failing, of powerlessness. their fear of boundarylessness, of nature unbridled and crouched for attack, their fear of the absence of so-called civilization, their fear of loneliness, of aggression both external and internal. In short, the terror of human freedom, the thing they coveted most of all. Romance offered writers not less but more, not a narrow ahistorical canvas, but a wide historical one, not escape, but entanglement. There is no romance free of what Herman Melville called the power of blackness, especially not in a country in which there was a resident population, already black, upon which the imagination could play, through which historical, moral, metaphysical, and social fears, problems, and dichotomies could be articulated. The slave population, it could be and was assumed, offered itself up as surrogate selves for meditation on problems of human freedom, its lure and elusiveness. This black population was available for meditations on terror, the terror of European outcasts, their dread of powerlessness, nature without limits. The concept of freedom did not emerge in a vacuum. As the sociologist Orlando Patterson has noted, we should not be surprised that the Enlightenment could accommodate slavery. We should be surprised if it did not. Black slavery enriched the country's creative possibilities, for in that construction of blackness and enslavement could be found not only the not free, but also, with the dramatic polarity created by skin color, the projection of the not me. The result was a playground for the imagination. What rose up out of collective needs to allay internal fears and to rationalize external exploitation was an American Africanism, a fabricated brew of darkness, otherness, alarm, and desire that is uniquely American. There also exists, of course, a European Africanism with a counterpart in colonial literature. Cultural identities are formed and informed by a nation's literature, and that what seemed to be on the mind of the literature in the United States was the self-conscious but highly problematical construction of the American as a new white man. Emerson's call for that new man in The American Scholar indicates the deliberateness of the construction, the conscious necessity for establishing difference. But the writers who responded to this call did not look solely to Europe to establish a reference for difference. There was a very theatrical difference underfoot. Writers were able to celebrate or deplore an identity already existing or rapidly taking a form that was elaborated through racial difference. How could one speak of profit, economy, labor, progress, suffragism, Christianity, the frontier, the formation of new states, the acquisition of new lands, education, transportation, freight and passengers, neighborhoods, the military, of almost anything and everything a country concerns itself with, without having as a referent, at the heart of the discourse, at the heart of definition, the presence of Africans and their descendants? It was not possible, and it did not happen. What did happen frequently was an effort to talk about these matters with a vocabulary designed to disguise the subject. It did not always succeed, and in the work of many writers, disguise was never intended. An instructive parallel to this willed, scholarly indifference is the centuries-long hysterical blindness to feminist discourse and the way in which women and women's so-called issues were read or unread. Africanism is the vehicle by which the American self knows itself as not enslaved but free, not repulsive but desirable, not helpless but licensed and powerful, not historyless but historical, not damned but innocent, not a blind accident of evolution, but a progressive fulfillment of destiny. That's one reason why it may be so difficult to effect change, but not impossible. Those are my fighting words. Add yours on Twitter, and remember to tag us at WMC Live and use the hashtag #FightingWords. And that's our show for this week. We'll be off next week, but then back at the same stand as usual the week after that. You can follow me on Twitter, Facebook, and now Instagram at @TheRobinMorgan, and you can check out my blog at robinmorgan.net and find my latest book of poems, Dark Matter, and my brand new novel, Parallax, wherever books are sold. Opinions expressed on this program do not necessarily represent the Women's Media Center. Here's the family for Women's Media Center Live. Executive producer as well as founding and sustaining sponsor, Regina K. Scully. WMC president and co-executive producer of this program, Julie Burton. I'm Robin Morgan, your producer and host. Thank you for being with us. Join us again next time on Women's Media Center Live.